Welcome to the series Sharing with Myhanh, Understanding Together, Peace Forever. In this series, we will explore one of the most important but often overlooked topics in retirement plan, inherited IRA and 401k accounts. When a loved one passes away, these accounts don't automatically work the way many families expect. The rules can be complex, different for spouses, children, or other beneficiaries, and recent changes like the SECURE Act have made them even more challenging to navigate. My goal is to break down these rules into simple, practical examples so you can clearly understand who actually inherits, what the tax consequences are, and how to plan properly to protect your family. Let's begin this journey together because when we truly understand, we can find peace of mind for ourselves and our loved one. To understand how IRA and 401k accounts are inherited, it's important to first define the concept of an estate. Upon a person's death, all of their assets, including real estate, bank accounts, IRA, 401k, and investment accounts, are initially considered part of the estate. At that point, documentation determines how the assets are distributed. Assets with valid beneficiary designation, such as IRA, 401k, life insurance with a beneficiary form, or assets placed in a trust, will pass directly to the named beneficiary. It doesn't have to go through the court system. For the assets without a valid beneficiary designation, remain in the estate and must go through the probate process. In such cases, the court distributes the assets according to the terms of your will if you have one, or by the state law if you don't. The probate process is often lengthy, costly, and can create additional stress for surviving family members. So that is why keeping your beneficiaries form current and using a trust when appropriate are key strategies to help your assets bypass probate and transfer smoothly to your loved one. In an IRA or 401k, the most important factors is not the will or the trust. It's the beneficiary form. This is the documentation that the plan custodians or financial institutions will use to decide who gets the money when the account owner passes away. In short, if you write someone's name in the beneficiary form, that person will inherit the account, even if your will says otherwise. But if the beneficiary form is left blank or is no longer valid, the entire account will fall into the estate. That means it must go through probate, a process that is slow, costly, and could also trigger the 5 year rule, forcing the account to be empty quickly and creating a heavy tax burden for the family. That is why the simplest way to protect your assets is to regularly review and update your beneficiary form, especially after a major life event such as marriage, divorce, or the birth of a child. Doing this helps your family avoid unnecessary risk and ensures your assets are preserved. Let's talk about SECURE Act, which stands for Setting Every Community Up for Retirement Enhancement Act. This law was first passed in 2019 and later expanded in 2022. It changed the rule for inherited IRA and 401k withdrawals. Before 2020, if the beneficiary was not a spouse, they could use what is called the stretch IRA. That meant they could spread withdrawals out over their lifetime, taking only a small amount each year based on life expectancy. This allowed the account to keep growing, tax defer, while providing steady income. But after 2020, everything shifted. Now, in most cases, non-spouse beneficiaries must withdraw the entire account within 10 years. The stretch IRA strategy is no longer available for most heirs. This is a big change because instead of stretching withdrawal over a lifetime, beneficiaries are forced to take the money out much faster, often leading to higher taxes in the shorter period of time. As I just mentioned, the SECURE Act limited the stretch IRA for most cases. Instead, there is now only two main rules, the 10 years rule and the 5 years rule. The 10 years rule. This is the most common rule. If the beneficiary is not a spouse, they are required to withdraw the entire account within 10 years of the account owner death. If the account owner died after reaching the required beginning date, current age is 73 years old. It will increase to 75 in 2023. Then beginning in 2025, the beneficiary must take annual required minimum distributions, RMDs, for the first 9 years, and the 10th year withdraw the remaining balance in full. However, there is a special group known as eligible designated beneficiaries. This includes spouses, children under age 21, disabled individuals, chronically ill individuals, or beneficiaries who are less than 10 years younger than the account owner. This group is still allowed to stretch withdrawals over their lifetime rather than being limited to 10 years rule. Let's talk about 5 years rule. This is less common but extremely important. The 5 years rule applies when there is no valid designated beneficiary. For example, if the beneficiary form listed the estate, a charity, or a trust that does not meet IRS requirements. Why are these not valid? Because the IRS only recognizes a designated beneficiary if it is an individual, a real person with a specific life expectancy that can be used to calculate distributions. Estate, charity, or a non-qualified trust are not individuals, so they cannot use the lifetime stretch options. The result, if the account owner died before required beginning date, the account must be fully withdrawn within 5 years. If the account owner died after required beginning date, the ghost rule applies based on the decedent's remaining life expectancy. 401k, which is one of the most common retirement accounts, follow a special rule because they are governed by ERISA, the Employee Retirement Income Security Act. This is a federal law designed to protect retirement benefits for employees and, importantly, for their spouses. Under ERISA, if the owner of the 401k is married, the legal spouse automatically becomes the primary beneficiary, no matter what the beneficiary form says. If the owner wants to leave the account to someone else, such as a child, the spouse must sign what is called spousal waiver, formally giving up those rights. In practice, this means the beneficiary form only applies if the spouse has already passed away or has signed the waiver. As long as the spouse is alive, the spouse will receive the entire account, even if someone else is listed on the form. So here is the key difference. If an IRA, the beneficiary form alone controls who received access, but with the 401k, federal law under ERISA always gives the first priority to the spouse. When the beneficiary is a spouse, They are far more flexible options compared to other beneficiaries. This is a particular important point in retirement law. Option number 1, roll over into their own IRA. The spouse can transfer the entire inherit IRA account into their own IRA. This allows tax defer and postpones withdrawals until reaching the RMD age. This is usually the most common choice if the spouse is still young and does not need the money immediately. Option number 2, keep it as an inherited IRA. An inherited IRA means a new IRA account opened by the beneficiary after inheriting assets from the deceased IRA owner. If they choose this option, the spouse can withdraw early without the 10% penalty, even if under the age 59 and a half. This is a big advantage for those who need immediate or short-term access to the funds. Option number 3, withdraw the entire amount immediately. They can withdraw everything, but income tax must be paid if it is traditional IRA. If it is a Roth IRA and the 5 years rule is met, then the withdrawal will be tax-free. In summary, compared to other beneficiaries who are generally required to follow 10 years rule, the spouse has more favorable choices, offering both flexibility in timing and tax optimization. When the beneficiary is not a spouse, they fall into a category of non-spouse beneficiary. Before 2020, these beneficiaries could use the stretch IRA strategy, taking distributions over their own life expectancy, which allowed them to extend withdrawals and reduce the tax burden. However, under the SECURE Act, non-spouse beneficiaries are now required to withdraw the entire account within 10 years of the account owner's death. If the decedent had already begun taking required minimum distributions, RMDs, the beneficiary may also have to continue those annual RMDs during the 10 years period. There are, however, some exceptions. Minor children under age 21, individuals with disabilities, and those with chronic illness might still be allowed to follow the stretch IRA rules based on life expectancy, or in the case of minors, delay the 10 years requirement until they reach age 21. Instead of going through dry theory, let's look at some real-life scenarios. By walking through examples, everything becomes much easier to understand and remember. Look at case number 1. Mr. A has retirement account worth $250,000. When he first opened the account, he filled out the beneficiary form and named his ex-wife as primary beneficiary and his 2 children as a contingent beneficiary. Later, he divorced and remarried and has a child with his new wife, but he forgot to update the beneficiary form. What happens next? With IRA account, if the ex-wife is still alive when Mr. A passes away, the ex-wife receives 100%. The new wife and their child will receive nothing. If the ex-wife passed away before Mr. A, the assets go to contingent beneficiary. In this case, the 2 children with the ex-wife. If there is no contingent, for example, the assets fall into the estate and must go through probate court. The new wife and the child will still not automatically receive anything. So the conclusion is this. With an IRA, everything depends on the beneficiary. If it's not updated, the risks are very high. With 401k, Because the 401k plans are governed by ERISA, Employee Retirement Income Security Act. Mr. A has remarried, current spouse automatically receive 100%, no matter what the beneficiary says. If Mr. A wants to leave the 401k to his child or anyone else, his current legal wife must sign a spousal waiver, a legal document give up her rights. Without that waiver, the current spouse is always the primary beneficiary. So conclusion is that with 401k, the legal spouse is always the top priority under federal law. This is a very different from the IRA, which follows only the beneficiary form. Case number 2. Mr. A has both IRA and 401k account with a total value of $250,000. However, he did not complete a beneficiary form. What happens with IRA account? Because there is no beneficiary form, the IRA access will fall into the estate. All funds must go through probate court for distribution. The court will follow the instructions in the will if one exists, or if there is no will, state intestacy laws will apply. With 401k account, since a 401k plans with governed by ERISA, if Mr. A is married, the legal spouse automatically becomes the primary beneficiary. If Mr. A is single and has not completed a beneficiary form, then the 401k will also fall into the estate and go through probate, just like the IRA. So the final outcome will be, with IRA account, goes into the estate and must go through probate. With 401k, if Mr. A married, spouse receives everything. If Mr. A single, it will go into the estate. So the key lesson from this example, not filling out a beneficiary is a major risk. Assets can get stuck in probate, causing delays, additional costs, and prevent the family from receiving funds quickly as intended. So in another video, I will share more about wills and trust, two important legal tools that help ensure your assets are distributed according to your wishes, minimize legal complication, and provide better protection for your loved ones. Thank you so much for watching today's session. I hope the information I share have helped you better understand IRA 401k and how to protect your family's assets. If you found this helpful, don't forget to like and subscribe so you don't miss my next videos. And if you have any questions, feel free to email me at thumbandwealthhealth@gmail.com or call me directly at 408-513-7350. I'll be happy to take the time to answer and help you find the solution that best fits your situation. I will see you again in sharing with Myhanh, understanding together, peace forever. Wishing you and your family good health, peace, and happiness.